Our last seating with regard to blocking charges, and that would be Melinda Hensel and Arnold Pearl, both of whom have testified before. Thanks again for coming.
Thank you for having me, Mr. Chairman. I can make this real short and easy. I don't support any changes really at all to the board's blocking policies. I think what exists works very well. I'd like to start off and say that I would oppose any criticism of the union viewpoint in regards to the delay that is incurred as a result of blocking charges. The delay in those cases is completely separate and apart from the delay that we're talking about in the other elements of the proposed rulemaking. Blocking charges are called blocking charges for a reason. It's because bad conduct has occurred, which does in fact require a delay in the process in order that employees may be able to freely and fairly exercise their rights. Trying to compare the two, like I said, the litigation issues pre-election and what occurs in the blocking delays is not an apples-to-apples comparison whatsoever. And so I would reject any criticism of our position as regards to we accept the delay that does occur in blocking charges. In the summary, you requested comments on various aspects of this of the blocking charge. First, should the regional director require an offer of proof when these charges are filed? I would not object to the submission of such an offer. However, I would object to the regional director making a decision on the conduct of the election or even proceeding with the hearing based solely on that offer of proof, because we are dealing in those cases with ULP charges, and there are credibility issues to be determined before one can decide if the charge has merit. I don't think you can make those determinations solely off of an offer of proof. But certainly it would assist to define the parameter of the charge and how particularly egregious the conduct was. In that regard, blocking charges, in my experience, are very typically investigated rather quickly. The case handling manual gives the regional director very broad discretion to decide how he or she is going to deal with the charges. I recall one instance we filed the charge. It was maybe 3 or 4 days before the election. We got the call the next day that you will be here with all of your witnesses and you will not leave until every single witness has given a statement, and we will issue a decision on the merits in advance of the election and make a decision as to whether or not it's going to proceed. We did that. We presented witnesses from 8 a.m. until 1 a.m. and the regional director did in fact issue his decision the next day. So the discretion that's provided for in the case handling manual is exercised by the regions. And I just don't see any need to change the way it's exercised. There were questions about whether or not an R case hearing should proceed in the event of the filing of blocking charges. Again, I believe that the case handling manual already sufficiently handles those questions that you've posed. In a type 1 case, the regional director can decide to proceed. Commonly in a type 2 case, because it might result in the dismissal of the petition, it will be held in abeyance pending. I think that that's a fair resolution of those two different types of cases. I suppose my objection to proceeding to hearing in a type 1 case is we may find ourselves in a position where if the conduct has been sufficiently egregious, we're going to have trouble gathering the witnesses that we need even to present our unit issues or exclusion issues. I have been in that circumstance where the witnesses really don't want to come forward because they've been sufficiently brainwashed by the employer, and it's been very difficult to present that case. However, I would say to the extent that we are able to dispose of administrative issues, it's worthwhile to do so. That way, once the charge is resolved, you can get yourself to election much faster. And again, I see my time is up. The difficulty there, though, is if the resolution of the charge ends up taking an especially lengthy time, and that can happen, you may get to the point where it is finally resolved and find that your unit's completely changed and you really need to go back through those procedures again. So it's a toss-up as to whether or not it's a waste of board resources to continue the process while you have a blocking charge pending.
Well, some might argue that, or some have argued that a blocking charge is a mischievous tool, particularly where the petition is for decertification. How do you respond to that?
I agree that all charges can be mischievous tools, not just blocking charges. Employers have been known to file charges, relating to the solicitation of cards in an attempt to block and delay. Sometimes when you've got an election with two rival unions involved, one files charges against the other, related to bad conduct in an attempt to delay, to have a longer period of time to get their voice out there. I can't say that it's never done. But at the same time, I think for the most part, our regional directors are quite good at seeing through the smoke. And they make typically good decisions on those charges, and that they do give a lot of thought to what the effect on the employees has been when making their decision as to whether or not to proceed.
Ms. Hensel, I want to just preface this by saying I really appreciate your contribution, and this applies to the speakers throughout the day today. I think people have been very thoughtful and very reflective, and and also very civil in terms of talking about these issues that have generated so much strong feelings on all sides. With respect to blocking charges, this is an area that's interesting because all 5 members are very interested in comments on the blocking charge doctrine. And I have a mechanics question and then more of a philosophical query. The mechanics question is, if we have a blocking charge and it remains unresolved for some period of time, and then if the blocking charge clears, the underlying ULP is subject to a resolution or there's ultimately an election. If an election takes place in months or in some cases years later, does it make sense to have a different election eligibility date and then a different Excelsior list as compared to what may have been an original Excelsior list that then becomes stale? What are your thoughts about that?
I think in some cases, depending on the length of time that's passed and whether or not the unit has changed substantially, it might be required. I actually don't like agreeing with that, but I agree that it might be required. If the unit hasn't changed all that much, and I don't know if there's a percentage of employee turnover you would ascribe to that, then I think it would be fair to go back to that original eligibility date, because I don't think that a party should benefit by the virtue of its own bad conduct, and the change in a unit description or the composition may actually end up benefiting that party.
It could go the other way, too.
It could. This is one of those. It's very...
Yeah.
I don't think you can predict.
Yeah, and my other more general question is, would you agree there's at least some tension, you know, from the employer side, employers are suggesting in many of the contributions we've received comments, you know, we have this process for representation elections, and there are these issues that are real issues that, you know, at least warrant resolution. And the proposed rule kind of resolves that by saying we want to resolve these issues, but we really need an election quickly, and then we can resolve the issues. And then the blocking charge doctrine, there are these issues that really are serious issues that require resolution, but are, with respect to blocking charges, we actually say, well, no, the election can wait. And I'm not asking you to embrace the idea that we should just abandon the blocking charge doctrine, but would you agree at least that the issues themselves raise kind of an interesting tension, because in both cases you have some legal issues that require resolution. In one case we're saying going to the election quickly doesn't matter. With respect to the blocking charges, if we stick with the current doctrine, at least with respect to many of them, we're saying actually the resolution of the charges is more important than proceeding to an election quickly.
I would go back to blocking charges are filed when the person or the entity filing doesn't feel like that there's a fair opportunity for an election anymore, and that's why it makes sense to stop the process and try to remedy the harm that's been caused. You know, if employees have been told, no, we're closing down and you guys will never work again if you do this, do you believe that it's possible to have a fair election? I don't. I don't think that it's possible. And the employees need the assurances of the government that that conduct was unlawful. They're not allowed to do that. They're not allowed to say that. And you need to see this notice posting for 60 days before we can let you go vote, to make sure that you understand that that's the case.
Yeah, I appreciate the response. Of course, in both cases, the alleged legal issues are unresolved at the time, which is the whole, it kind of begs the question of when should the resolution take place. But
right.
I appreciate the response.
You know, there's, because especially in the type 1 cases, the union or whoever files does have the option of filing a request to proceed. And in my experience, when we do that, they're typically honored. You know, that requires the party filing the request to think long and hard and really know its bargaining unit as to what has occurred. You know, in that regard, there were requests for comments about whether or not the election should happen, and then the ballot should just be impounded. Again, this is a tough topic. There's instances where that might be a fine solution, but I don't think it's a good solution for all instances or even most.
Okay, thank you.
If I could just jump in. First off, thank you both personally in our last sitting of the day, and thank all the speakers. We went a little bit long, but everybody made invaluable contributions, and I appreciate everybody having come out and contributed. And I would also like to say that I fully accept the good faith behind the unions and labor movement's position that blocking charges are an important and in some cases necessary part of the process, because just because there's an election that may be pending, that doesn't mean, hey, anything goes. And I think we're all sort of unified on that. I guess my question is, to the extent that we wanted to put sort of a quasi-10J standard of if it's irremediable conduct without a postponement, put that in our regulations on blocking charges and get out of this sort of type 1, type 2 arena, would that be the phraseology that would make sense to you, irremediable without postponement of an election?
I suppose I could wrap my arms around that. I mean, again, you know, it's another one of those sort of vague board phrases that's always subject to interpretation. You know, how would you define that phrase?
Right. Well, basically, we're not going to have laboratory conditions without a postponement, without putting the election basically into petition in abeyance, because it may be a decertification petition, for example, in my example.
I haven't really considered such a thing. Can I think about that a little bit?
Of course. I mean, the comments period is over with, but when, I'll let you think about it.
Thank you.